Patrick.
Thank you very much. So, where we got to this morning, I had just been going through the relevant factors, which we see cumulatively meant that the test of necessary gravity was met. And if we take together what I'd said about Article 1F(c) and its interpretation, and what I'd said about relevant factors, we were left in this position before I turn to my grounds of appeal and what the upper tribunal had to say. The bottom line was this. This was an individual with a conviction for inciting and encouraging terrorism. Now, I'm happy to leave Section 54 out of the equation, given what was said by the bench this morning, but squarely within, that conviction squarely within the terms of the various UN resolutions to which I take you. And bear in mind that the courts have said that UN resolutions are an indicator of the meaning of the UN Charter. She had the intent to incite and encourage, we know that. We know that she held extremist views. We know that she had a large number of followers and tweeted or retweeted up to 60 times a day over the course of a whole year. The FTT describing this as prolific and the sentencing judge describing it as being on a massive scale. The content was vile and expressly incited and encouraged terrorism. And there was external validation of her tweeting because her tweeting was being heard. Because by way of, we know that from the indication about the website.
Well, it wasn't being heard. Was it? It was being read.
It was being read. Yes, sorry.
Unless it was some
I
new
thought you were making it more semantic.
I don't know about.
Absolutely right. Well, yes, unless you needed, you had.
I'm just trying to show I understand about Twitter.
Absolutely right. Sorry, I'll rephrase and say she was being read, and what she was being said was being taken note of because a website associated with Al-Qaeda described her as one of 66 important jihadist accounts. And remember what I said when I was going through the case law, there is no need, this is Yusuf, there is no need to show that someone actually was encouraged or incited to commit a particular act of terrorism. In my respectful submission, given that combination of facts, the test of gravity was plainly met, and I put it more highly than that. I say, as I said to the First Tier Tribunal, that the only possible conclusion had to be sufficient. The test of sufficient gravity had been met. So not just nature and quality, but sufficient gravity. Now, the First Tier Tribunal, we know, took a different view, and I'm grateful to my learned friend for going through that decision in some detail so that I don't need to. They set out their specific findings, and it's not my submission, and never was my submission, that they failed to take something, a particular factor into account. What I did repeatedly say to the First Tier Tribunal was that they could not go behind the findings of the sentencing judge, the factual findings of the sentencing judge. And the reason for that being that he'd had the benefit of being at the trial and he had considered the underlying evidence. Mr. Mackenzie accepted that, as we've seen, and he's already taken you to the relevant paragraphs of the First Tier Tribunal's decision. And the First Tier Tribunal said, insofar as they go, they represent reliable factual statements. That's paragraph 112 of the decision, which again you have already seen. Now, if I may, just take you to one paragraph of the First Tier Tribunal's decision before I leave it. It's paragraph 234, which is on page 123 of the bundle. Now, here they are. It's within the body of the section on Article 1F(c), and they are considering a number of relevant factors. And at 234, they consider the section, well, the finding fact set out by the sentencing judge related to the website associated with Al-Qaeda. The absence of background detail has significantly limited our ability to assess this issue in any more detail. Yes, absolutely. We iterate here that there is no evidence on the particular links. Yes. How many visitors have been to the site, how the particular listing question was compiled. whilst the inclusion of Helen's Twitter account on the website is a fact and is of relevance, it does not, in our view, represent a particularly strong factor weighing in the respondent's favour. Now, this is where we see that I'll come on to my grounds in a moment, but this is where we see that they effectively went behind what had been said. Now, except what they do here is that they give limited weight or less weight because they didn't know more. And in my respectful submission,
less weight than what?
They say it's a fact and is of relevant, but is not a particularly strong factor.
Yes, but you were drawing a comparison between the weight they gave it and the weight and some other weight, because you said less weight. Less weight than what?
They accorded it. They noted the fact, but did not give it. They did not consider it a particularly strong factor because they didn't know more. That's what I say.
Right.
I'm not sure I understand the question. I'm so sorry. It's my fault.
No, it's my fault. All right, so they didn't consider it a particularly strong factor because they didn't know much about it.
Yes.
Right.
When in fact I say on its facts, the fact in and of itself was sufficient to show that there had been external validation. It was on any basis, it was sufficient to show just that, external validation, external readership and commendation as an important jihadist event.
Right.
And the reason I take you to that is because in due course the Upper Tribunal concludes that in and of itself this got it over the threshold of gravity. So we'll come back, we'll obviously move on to the Upper Tribunal's decision in a moment. Now, my grounds of appeal, page 57 of the bundle. My learned friend have already taken you to, but I take you to it again because of the request earlier this morning that I point out where it is that I had, that it was alleged on behalf of Secretary of State that the decision was irrational. Now, 57, so the top two paragraphs, paragraphs 3 and 4 there on page 57 is where we addressed Article 1SC. And what I said is in effect that this is in the last sort of 2 or 3 lines of the paragraph. All these issues go to gravity, but the First Tier Tribunal appears to have focused almost exclusively on the consequence of tweeting, and then this, rather than the fact that the acts in and of themselves were of sufficient gravity. This amounts to an error of law. Now, I appreciate the word irrational is not used, and I can't pretend it was.
No.
But as my own friend's skeleton argument acknowledges, this was at least in part a rationality challenge, which is the acts in and of themselves were of sufficient gravity, and it was an error of law to conclude otherwise. And when we look at the Upper Tribunal's decision, we'll see that they understood that that was the way that the case was being put. And in particular, if we look at paragraph, sorry, just give me one moment. I think it's 57, but I just want to turn it up to be sure.
So where does I'm just looking at the ground of appeal.
Of course.
You don't refer in the ground of appeal to validation, external validation. Is that your way of putting it now? It doesn't seem to be the way you put it then.
Well, what I do see is that
because included is rather yeah, all right.
Okay, so what the paragraph says is that they'd gone behind the remarks of the sentencing judge. So they'd gone behind, so in that paragraph which I just took you to, they had concluded that they didn't have enough. And I say that's going behind the findings of the sentencing judge, who'd already concluded that there was external validation. So that's the external validation point. And then secondly, the First Tier Tribunal appears to have focused almost exclusively on the consequences rather than the fact that the acts in and of themselves were of sufficient gravity. So 2 aspects to the ground.
So are you going to show us the passage in the remarks of the sentencing judge which you argue the FTT went behind?
Well, I think I'll happily take you back to the we were in before.
Well, sorry, it's probably my fault. I just want to be clear.
Not at all. If I'm not making myself clear enough, then we absolutely have to go back to it. So, the sentencing remarks are set out in detail at paragraph 17 onwards of the First Tier Tribunal's decision. So, page 84.
Yeah.
And the second paragraph on page 84 there, in paragraph 17, is about the on a site associated with Al-Qaeda, your Twitter account was noted to be one of 66 important jihadist accounts.
Right. But that's in that the sentence begins, an indication of how busy you were in this activity. So the sentencing judge doesn't seem to be saying an indication of how serious this was, is that you were externally validated, or I mean, he doesn't seem to be making the point that you seem to be making now.
Yes, because that I agree, and I think I said earlier today that the answer to that is that the sentencing judge wasn't deciding whether or not the test of gravity was met. He was simply setting out facts.
So I'm just trying to understand the submission that the FTT went behind the sentencing remarks.
Perhaps I can put it differently. The First Tier Tribunal had the sentencing remarks. There were said to be agreed facts within those sentencing remarks, one of which was that she had been mentioned on a site associated with Al-Qaeda as one of 66 important jihadist accounts. And yet, at paragraph 234, the tribunal says, we don't know enough. And I say that amounts to going behind the clear finding that there was external validation on that site.
But he hasn't made that clear finding. He's made a different finding. He's used this as evidence of how busy the respondent was.
But the fact in itself went to two different issues, didn't it? It went to the fact that she had been busy, so she had come to the attention of that website. But it also went to the fact that she was noted as one of 66 important jihadist accounts also went to the fact that she had been noticed, that she had been read.
But if you go back and read paragraph 129 of the FTT's determination, which is cross-referred to in the paragraph with which we take issue, paragraph 234, they expressly take into account what the sentencing judge said.
Yes.
We find that Twitter account did in fact appear on a website associated with Al-Qaeda. It was a list of 66 important jihadist accounts. So that's not going behind the sentencing judge's sentencing remarks. That's following them.
Well, that's noting them.
What they then go to say is there's a lot of stuff that this doesn't tell us, and then they explain what isn't obvious from the remarks which they accept. So what I'm trying to understand is what's wrong with that.
I think what we say that is wrong with that is that when you're assessing gravity, I'm not sure my submission is going to improve by repetition, but I'll try. What's happened here is they note correctly the fact. They note that it's an agreed fact and that they shouldn't go behind it. Yeah. But then they go on to accord less weight to that fact in an assessment of gravity on the basis that they don't have more.
But you've used the phrase less weight again, so what are you comparing it with?
We see that this was the central piece of evidence, the central fact that showed that this went beyond the teenager calling for the jihad in his bedroom. This was the central factor. And yet, because they didn't have more, they say, in an assessment of gravity, they say, it does not, in our view, represent a particularly strong factor weighing in the respondent's favour. Why not?
Well, they've explained why in paragraph 120. Well, all right, we're going around in circles.
With the greatest respect, I don't think they have. They've said we want more, but perhaps going behind the sentencing judgment remarks is the most helpful way of putting it. But it is what it is doing is requiring more than they have in order to give weight to something.
Yeah.
And in my respectful submission, the fact in and of itself demonstrated sufficient gravity. Okay. And the upper tribunal agreed.
Yeah, all right. So that's your submission actually boils down to say it isn't a submission that they went behind the sentencing remarks. Your submission is that they should have taken that sentence in the sentencing remarks as evidence in and of itself of sufficient gravity. That's what it boils down to, isn't it?
It is.
Yeah. Okay.
And then if we turn to the upper tribunal's decision, actually before we turn to the upper tribunal's decision, I should say a word or two about the case law that my learned friend refers to support his submission that the upper tribunal should not interfere with decisions of the First Tier Tribunal unless, except for in specified circumstances. So can I just say two things about that? So first of all, I want to say a word or two about Greenwood, which I don't think you referred to, but if we turn to the case of Greenwood, which is behind tab 3, and we look at paragraph 17. So this case is obviously about a different. It's different. It was about whether or not the requirements of paragraphs 399 and 399A of the immigration rules were met or not. But a similar point was made that the upper tribunal ought not to interfere with the decision of the First Tier Tribunal. And if we look at paragraph 17, one of the questions that arose before the upper tribunal is whether the judge committed any error of law in his application of the correct legal test. And they say a word or two about irrationality and when a tribunal.
So this is a decision of the upper tribunal.
It is, exactly.
Yeah. Okay.
This tribunal can find an error of law in the context of the dispute only if the outcome of the application of the correct legal test is vitiated by irrationality. This is self-evidently an elevated threshold. One is rarely satisfied in practice, does not expressly feature in many of the recent Court of Appeal decisions. And then I'm not going to read the rest of it. I'm sure you can cast your eye at it. Now, I don't seek to take away from what's said there at all. What I do say is, if a decision is irrational, then the First Tier Tribunal's decision is rational, then it is entirely appropriate for the upper tribunal.
Well, I don't think there's any dispute about that.
Exactly. And if we look, we will see in a moment that the tribunal expressly considered whether it was making the Greenwood paragraph 17 mistake and concluded that it wasn't. So we'll come on to that. The second thing I wish to say about the case law dealing with when the tribunal should interfere is the case of Lowe, which my learned friend did take you to. And he took you to a number of paragraphs, but I only, for these purposes, I'm going to take you to paragraph 19 of that judgment. And this is making good the point I made earlier. Paragraph 19.
Sorry, could you remind us which tab that is?
Of course. Apologies.
That's my fault. Yes, just got
tab
there.
5 and paragraph 19.
Thank you.
So in the context of, again, paragraph, I should say, just if we cast our eyes on paragraph 21 first, the tribunal judge accepted the submission. Perversely was not easy to prove, and the upper tribunal could only interfere if it's the case where the conclusion it reached was not open to the FTT. Fine. But at paragraph 19, one of the factors that played into that equation was that the judge was entitled to assess the appellant that he saw in the witness box and to decide, in light of all the information before him, whether or not he would face very significant obstacles to integration. So that was the test that was being applied in that case. Now, I can see that in such cases, the First Tier Tribunal has a massive advantage over the upper tribunal judge. So they've seen and heard all the evidence. So the appellant has given evidence on difficult issues, which involve...
Yeah, but this isn't one of those cases. Nobody's suggesting it is, but it is nevertheless the case that it's for the First Tier Tribunal to make the initial assessment. And
yes.
Their assessment can only be interfered with on established principles.
That's right. I mean, I think that's exactly right. The only
and the fact that the upper tribunal is in as good a position as the FTT to make an ultimate decision, if there is an error of law, as I said this morning, is putting the cart before the horse. We've got to find the error of law first.
We do, absolutely. I only address the kind of principle, because very often the reason why the upper tribunal shouldn't interfere is because the FTT was in a better position, actually, to judge the facts. But that's not the case here. That's all I see.
Right.
Now, Okay, so then turning to the tribunal decision itself. Again, my learned friend has taken you to this in some detail. But there are some key paragraphs which I think I want to draw to your attention. The first is paragraph 7. As my learned friend has already foreshadowed. Paragraph 7 is obviously key. The claimant has committed offences. Page 36 of the bundle. Sorry, that wasn't clear. The claimant has committed offences under the Terrorism Act. Such offences are emotive, and it's perhaps particularly important that we remind ourselves that we are not, at least initially, primary decision makers. Our function is to see if the Secretary of State is able to show the First Tier Tribunal's decision to allow the appeal was wrong in law. We must be careful to apply our minds to this.
I mean, we've read this paragraph,
yes.
and they have clearly given themselves a correct instruction in law at the beginning of the decision. But the question is, when you read the rest of the decision, have they followed it?
Can I then turn your attention to paragraph 70 of the decision, which is page 46. And this is where I see they deal with Greenwood and the other cases. We have also applied our minds carefully to the question of whether we are merely disagreeing.
Yeah, no, we've read this paragraph as well.
Did they actually mention Greenwood?
No, they don't mention Greenwood.
This is where they're
no terms, but that's where they are applying the right. And if we turn to paragraph 55, we can see how the tribunal categorised the challenge or the appeal that was being run on behalf of the Secretary of State. It is the Secretary of State's contention the tribunal was not entitled to find on the evidence before it that the high threshold had not been reached. In my respectful submission, that's a correct categorisation of the way that I put the case, but it's also, without doubt, in my submission, it is accepting that the submission on behalf of the Secretary of State is that no rational tribunal could have concluded that the high threshold could not have been met. Now, the word rationality doesn't appear, but that can only be what that sentence means.
Sorry, I missed which paragraph.
It is paragraph 55 on page 43 of the book. So they accept and understand that this is a rationality challenge when it comes down to it.
But that's not the way it's put in the ground of appeal for which permission was given, because we've looked at that. It's paragraph 4 on page 77.
Page, sorry, 77.
Well, he showed us that we've already looked at it twice. The grounds of appeal from the First Tier Tribunal to the Upper Tribunal, paragraph 4 on page 77, it is not a rationality challenge. Well, we've looked at it in detail. First it says they went behind the remarks of the sentencing judge who'd already made findings on the gravity of the conduct. That's the first point that's taken. All these issues go to the gravity acts. FTC appears to have focused almost exclusively on the consequences rather than the fact that the acts in themselves are of sufficient gravity.
Yes, so my submission earlier was that those words, that rather than in and of themselves the acts were of sufficient gravity,
right,
is what I see. Could have been put more clearly, but was amounted to a rationality challenge. And in fact, the way it was put to the Upper Tribunal, it was a rationality challenge. And that's why at paragraph 55, they summarise the argument as being a rationality challenge. So then we turn to the way that the matter is assessed. A learned friend has taken you through 56, 57, 58, 59. And I think it's accepted that the key paragraphs start at paragraph 63. 3. There are 3 factors in the tribunal's reasoning which we find do at least cumulatively make out the necessary gravity. Now, my left friend says that's just going straight on to make the decision. It isn't. It's setting out 3 reasons why, on any basis, the evidence before the First Tier Tribunal made out the necessary gravity. It's responding directly to the challenge put by the Secretary of State, set out at 55. The tribunal hadn't been entitled to find on the evidence, could have only found on the evidence that the high threshold had been reached. And they say we agree. And these are the reasons why we agree. First volume, second timescale, and I accept the point made earlier this morning that it's not always clear which point is point 1 and point 2 and point 3. But certainly 1 and 2 seem tolerably clear because it says first and second. In relation to timescale and volume, they say at the end of 56, these are levels of activity which take the case away from isolated youth ranting and elevate it into a higher category. And the First Tier Tribunal was just wrong to take a contrary view. But then, it's hard to tell whether it's 3 or 4, but at 68, they say this. We do find it significant the website was on a site associated with Al-Qaeda. We would have liked to know more, so they accept the criticism. But we find this clear if limited description is enough to show the claimant's activities are of sufficient prominence to be commended by Al-Qaeda. And they were wrong, and this is the important sentence, with great respect, to say that this was not a factor singularly or cumulatively to elevate the conduct as sufficiently grave and severe to disqualify the claimant. Now that's a finding of an error of law. It's saying that they were wrong in law. I appreciate the word wrong rather than wrong in law, but I think Mr. Mackenzie all but accepted that wrong might mean wrong. But that's a finding that that factor in and of itself was sufficient, and the tribunal were irrational to conclude otherwise. Now, I appreciate again, the word irrational does not appear, but that can only be the finding. That's the error of law. And they don't say, this is what we decide. They say the First Tier Tribunal were wrong to conclude otherwise. And then they go straight on to say, paragraph 70, we thought very carefully about whether actually what we're doing is just disagreeing, but we're not. And that's really important in context, because that comes immediately after an analysis of why the First Tier Tribunal, in their view, had reached an irrational conclusion. Now, if I turn back to the 3 factors, or maybe there are 4. We look first of all at volume. And the First Tier, the tribunal identified that this is one of the factors. One of the factors was the number of tweets, and it elevated, it took the case away from isolated youth ranting. And they say the FTT was wrong to take a contrary view. Well, that's, I say, a permissible categorization of the First Tier Tribunal's conclusion, i.e. it was entirely permissible of the upper tribunal to conclude that over 50 tweets a day, or up to 60 tweets a day, over 347 days, could not on any rational basis be given anything other than significant weight when assessing gravity. And then, I think we've looked at the second and the third, but at paragraph 71, they go on to put a bit more flesh on the bones, if I can put it that way. We find that a person who sets out to encourage terrorism and does so by circulating encouraging and destructive material over the internet many times a day for the best part of the year cannot avoid being found to have been undermining the purpose of the United Nations. The necessarily high threshold, brackets, correctly directing themselves to the correct test, is crossed by the repetition of the offences. In this case, it's compounded by the clear evidence that there was success in the project is the conduct was commended by an Al-Qaeda supporting organisation. That is independent evidence of the importance of the conduct. First Tier Tribunal should have given a lot more weight to these things, which I'm going to come back in a moment. That is why we found finding the tribunal was wrong and why we overturn it. Now that is, I mean, the words don't really matter. What is actually being found here is that the First Tier Tribunal, on the evidence it had before, it could not have reached the conclusion that the high threshold was on any basis met. Now, I understand, of course, I said I'd come back to weight. I understand, of course, that weight is a matter of decision. But if you're concluding that a decision of a lower tribunal is irrational, you are necessarily saying that the weight that was accorded was inappropriate. Because if the weight wasn't inappropriate, it wouldn't have been irrational. So I see those words are just a consequence of an ultimate finding of irrationality. Now, in my respectful submission, if you have a decision where a tribunal has correctly directed itself at the outset of the decision and at the end of the decision of its role, it has correctly identified the Secretary of State's position as being no rational First Tier Tribunal could have concluded on the facts that the gravity was not made out. And you've got a tribunal who has set out why, in their view, on any basis, gravity was made out. Then that is A, a decision which directs itself correctly, B, a decision which clearly, in my respectful submission, reaches a view that it was entitled, that was permissible, that it was entitled to reach.
Does that matter? I mean, isn't the point that it's saying entitled to reach? This is the upper tribunal as an appeal. I understand you say as an appeal tribunal, the conclusion they reached was that it was irrational.
Yes, that's
not a conclusion. That's not like a first instance finding of fact. That's a find. The reason it works like that is because that's a conclusion of principle of law. Yeah. So from the point of view of an appellate court that we are, yeah, we don't treat decisions like that as if, well, it was open to them to come to that conclusion.
Well, you have to find that it was wrong of them to come to that conclusion.
Yes, but that's all, wrong as a matter of principle, not according. It's not a finding of fact which is accorded. No. So I don't know. But the only reason I reacted is because that's what it sounded like your submission.
No, what the upper tribunal is doing here.
I understand what you said the upper tribunal was doing.
Yeah.
I do, but you weren't talking about that. You were making a point to us about what we should be doing relative to the upper tribunal's submission.
No, I accept that. What I say is they made a finding on the facts that the decision of the First Tier Tribunal was irrational. They said, as they were entitled to do, having looked at all the evidence and the facts, there's no conceivable basis on which the First Tier Tribunal could have taken the view. And they also say, in and of itself, the jihadist account website was in and of itself sufficient.
Well, they don't say that, I'm sorry.
But they say...
The 3 lines up from the bottom of page 45, they say, well, let's take it 4 lines up. Tribunal was wrong to say that this was not a factor singularly or cumulative.
Yes.
So they don't say it was enough of itself. They say it was wrong to say that it wasn't cumulatively and
singularly.
They rule both out. So they're not saying this sentence doesn't mean, does it? This was enough on its own, and no rational tribunal could have found otherwise. It's not the meaning of the sentence.
But also the next sentence, it is clear evidence that the claimant's intended behaviour mattered to Al-Qaeda. I mean, it isn't clear evidence that it mattered, is it? I mean, they seem to have made that up, don't they?
Well, I think what they say is, I'm not sure I'm sorry, I'm really sorry, I don't follow
It's a confusing sentence because it says they were wrong to say that this was not a fact.
I mean, there are too many negatives.
There are too many negatives. But they're saying, what the First Tier Tribunal said was that neither singularly nor cumulatively was this a factor that was enough.
Yeah.
And they were wrong about that. Yeah. But that encompasses the possibility that they were wrong to say that it wasn't cumulatively enough, taken together with everything else. So it follows that it's not a clear finding that the First Tier Tribunal was bound to find, and this you say was your submission, was bound to find that in and of itself was enough.
I think, I mean...
I know that's convoluted, but that's how I'm reading it at the moment.
I think I understand, and I think again, language may be inelegant, but I think what it's intended to say is, this was not, I mean, only because I was there and I remember what they said, but they were intending to say, so forget or cumulatively for the moment, they were wrong to say this wasn't a factor in and of itself which elevated the conduct, so singular, right? So, in my respectful submission, that must mean, in and of itself, they were wrong to say that this factor in and of itself wasn't enough, right? So if we'd left out the words or cumulatively, that must mean what that.
If the words are all cumulatively.
Yeah.
If you add in or cumulatively, I think what was intended to be said is it was also wrong to find that this factor in combination with others wasn't enough. That's what that sentence says and means. That's certainly my submission.
I understand the submission.
Yeah. I mean, I suppose it's like anything. It's like when you say when a factor has.
Well, it would have been so much easier for you and for us if in this page and a half there's somewhere said the only rational conclusion to be drawn from the evidence before the tribunal was that the threshold of gravity was crossed, and it would have been polite actually to the First Tier Tribunal, with which they were respectfully disagreeing, to explain not just that they thought they were wrong, but that they thought that they behaved irrationally, because that's the test, as they know.
I couldn't agree more. And if everyone expressed themselves clearly all the time, we'd have far less cases in the courts, right? I mean, that's how it works, and that's unfortunately why we end up in the courts, because people don't express themselves clearly enough. But in my respectful submission, taking this decision as a whole, and given the way that they set out what my position was at appeal on behalf of the Secretary of State, of course, they can only meet this combination of this judgment can only amount to a decision that it wasn't a decision that was open to them. And I appreciate we spent a lot of time going through the First Tier Tribunal's decision and the Upper Tribunal's decision, but the general rule of thumb is we don't treat these decisions as a statute. We don't nitpick them. We look at how they can fairly be interpreted. And in my respectful submission, the way this can be fairly interpreted as we just don't think on the evidence that you could have come to this conclusion. And the court should be really slow to interfere with that. This court should be very slow to interfere with that. Unless you take the view that it was wrong of them to conclude the decision was irrational, the underlying FTT decision was irrational. Now, given that one of the parties, the Secretary of State, had been submitting throughout the process that the gravity test was met without doubt on the facts of the case, it can't possibly be said that the Upper Tribunal were wrong to agree with that position. That's what they did. They just agreed with the Secretary of State's position. They said, oh yeah, on the facts, gravity was made out. We're not satisfied that any other answer would have been possible. That's what they said. My learned friend then, I'm not sure I can usefully add to what I've said about that aspect of my learned friend's challenge. He also...
Sorry, it's your challenge.
Sorry?
It's your challenge. You'll repeat. Oh no, sorry, you're quite right. Sorry.
It feels like
It was your challenge.
right
Sorry, it was
now,
your
but
challenge at the Upper Tribunal stage, and his challenge
I think
is
you'll
sorry,
find
my
me
fault.
one at the Upper Tribunal.
Yes, I've got so enmeshed in the decision of the Upper Tribunal.
No. It was our decision. The First Tier Tribunal obviously found for the appellant.
Yeah, that's
Found
all right.
for the
I have got that sorted out.
Not at all. My learned friend's second ground relates to errors in remaking, and we don't accept that. Now, my skeleton argument sets this out really neatly, if I do say so myself, at paragraph 21. So I don't know if you have a copy of that. going to be effectively reading from that. Well, I mean, I think I'm not going to read 21, which effectively sets out the different factors. And we see.
Forgive me, how does remaking fit into a rationality challenge? I understand if there's an error of law, not a rationality error, but another error, that vitiates the decision, then it has to be remade.
Yeah.
I understand that.
Yeah.
But if the conclusion by the appeal court is that no rational tribunal could have come to the decision they came to,
Yes.
why do you need to remake it? You've decided that no rational conclusion,
Well, you don't need to remake it. That's why the appellate tribunal substitutes its own finding. It could have sent it back to the First Tier Tribunal. Could have said, we find an error of law. You didn't take into account X, Y, and Z. And then it could have sent it back. But it didn't. It decided that it would substitute. If you look
the point in this case is that you say that the appellate tribunal's decision was that no rational tribunal could come to any other conclusion than that it was of sufficient gravity.
That's right.
So I don't understand why you need to remake the decision in those circumstances. There's nothing to remake.
Good point.
I'm really sorry. Who
The appellate
should
tribunal.
remake it?
The appellate tribunal. Your point is,
Yes.
and I understand the point you're making. I really do. That the appellate tribunal decided that no rational conclusion could be reached other than that the offence was of sufficient gravity.
Yeah, it accepted the Secretary of State's position.
Well,
yes.
Fine, but they came to that conclusion. If you've come to that conclusion that there's no rational answer other than sufficient gravity, there's no decision to remake.
That's exactly right. But
Right.
my learned friend, the way he puts his case is, if I'm
Well,
wrong
that's his
about
case.
point
No,
one,
of course, he says they're
Yeah.
wrong,
yeah,
and he says that's not what they did, and then what they did is they remade the decision, and he criticises the way they did it.
that's right.
But
But
you sounded like you were agreeing with him that they remade the decision, which is why I reacted, because it doesn't seem to fit in with your appeal.
no, I think, no. What I say is, they didn't remake the decision. They concluded the decision was irrational, and then substituted. And if you look at the end of the decision on page 47, we set aside this decision and substitute decision dismissing the claimant's appeal.
Right.
So that
Yeah.
It can't be categorized as remaking the decision. What they did is they looked at all the factors. If you're trying to determine whether a decision is irrational, it is permissible to look at all the underlying facts and factors, right? You have to do that because that's the only basis on which you could decide. You have to take everything into account and say, well, look, could no rational decision maker reach that conclusion? Now, that exercise sometimes looks a bit as if you're remaking a decision, but you aren't remaking a decision. You're just looking at all the factors and trying to come to that conclusion. Was it rational or not? That's what they did.
Right.
They didn't go on to remake it. They just substituted their view.
Okay.
And I think that's what I see. Right. Now, I'm just going on to address the final points made by my learned friend. And in particular, the 3 points he makes at paragraph 67 of his skeleton. And this is paragraph 24 of my own skeleton. Now, his first point was that the appellate tribunal did not. Just give me a moment. I'm just going to turn up his skeleton so that I'm not saying anything unclear. So, paragraph 67 of his skeleton, which is page 28 of the bundle, he says the analysis doesn't include any application of the judgment of Irwin, Lewis's Irwin in Yusuf and N2. And what I say in response to that is it plainly does include an application of Yusuf. So it's clear from the face of the decision that the tribunal was well aware of that case and quoted all the relevant sections, paragraph 29. It noted the express terms of resolution 2178 at 61 and then went on to do the three-pronged exercise, which we've looked at repeatedly now, concluding that the conduct did make out the necessary gravity. So those aspects were all related to the gravity of the conduct. And the tribunal expressly notes at 65, contrary to the example in Yusuf, the acts were not someone sounding off, but persistent as well as large-scale misconduct. So the tribunal effectively accepted that the fact that the appellant's Twitter account had been both identified and held out as being important to have an account by an organisation linked to Al-Qaeda was a factor which in and of itself rendered the conduct sufficiently grave, fell within the ambit of Yusuf. So that is an application of Yusuf without question on the face of the decision. Secondly, it said that there was a misapplication of the relevant case law because the test for offences of terrorism in domestic criminal law and the test for exclusion in international refugee law are not the same. Now, what I say in response to that is, again, the upper tribunal did not conclude that the test for offences of domestic law and the test for exclusion in international refugee were the same. It's simply noted, and this is clear from the face of the decision again, that the facts of the appellant's conviction was also a strong indicator, not in and of itself, but was a strong indicator that the requirements of Article 1FC were met, as I have submitted today myself. And given the wording of Section 54, and given the application of Article 1F, and takes into account acts of encouraging or inducing others to commit, it's particularly difficult to see, frankly, how the upper tribunal's reasoning could amount to an error of law in those circumstances. And then finally, there's a sort of splitting here is argument at 367.3 of my learned friend's skeleton argument that the Secretary of State did not contend that the EE's Twitter activity had been commended by Al-Qaeda. And what I say in respect of that is that assertion, as opposed to mentioned on a site associated with Al-Qaeda, is splitting hairs, but it's ultimately irrelevant to the consideration of the issues. The remarks were made by the sentencing judge on material before him at the criminal trial. The fact that this material was not available to the tribunal doesn't detract from the basic facts, as I've already identified. They are. And that fact, as I've already submitted maybe several times, is that elevated the case from that of a teenager calling for jihad in his bedroom to that of a teenager calling for jihad in his bedroom and being expressly recognised as having an important role in doing so. It's also important to understand that the upper tribunal goes on to effectively correct itself in any event. So if we look at paragraph 71 of the decision of the upper tribunal at page 46, they say this: in this case, it's compounded by the clear evidence that there was success in the project because the conductor was commended by an Al-Qaeda supporting organisation. So in my respectful submission, they correct any misunderstanding in any event. Can I just, as I said at the outset, check my mobile phone, just to make sure that my instructing says here is not messaged. No, I don't have any messages from my instructing solicitor, so unless I can assist you further, those are, I think all the Secretary of State. Any questions?
Any questions? No?
Thank you very much.
All right,
indeed.
thank you very much. Yes, Mr. Mackenzie.
Thank you, Melody. Just very briefly, my learned friend has honed her argument, perhaps can put it that way, to say that no rational tribunal could have reached the view that this First Tier Tribunal did. Well, with respect, it's very clear it's not the basis on which permission to appeal was sought, nor was it the basis on which permission to appeal was granted, nor was it how the argument developed at the hearing, which is why I took you through the submissions at the hearing, which all concerned weight and relevance of factors. And of course, there's no application to amend the grounds. So, if the tribunal did understand, and I don't accept that they did, but if they did understand the case before them to be no rational tribunal could have reached this view, they were wrong with respect. That wasn't how it was being put. And perhaps more importantly, they don't go on to say that themselves. That we've seen the passages where they talk in terms of weight and disagreement, and they certainly don't, as my Lord observed, expressed themselves in terms of there being only one conclusion available. Unless there's anything else I can assist with.
No. All right. Well, can I thank you both very much indeed for your very helpful written and oral submissions. We're not going to give an extemporary judgment now. We will reserve our judgments, and in the usual way, judgment will be circulated in draft for corrections of obvious errors. And if you could try and agree a draft order between you, that would be very helpful. If there's anything you can't agree about, could we have written submissions and we'll resolve any disagreements in writing rather than having a hearing. I think it's likely that judgment will be handed down in accordance with the protocol, so it will be handed down remotely. Thank you very much.
All right, nice to see you.
Nice to see you. Take care.
Thank you very much.
message for Rose. It's Lucy in Court 74. It's just to let you know that judgment has been reserved. Bye.